Paul. Yes. I'm just looking at the difference between Amendment number 5 and Amendment number 14. A lot of us get confused about this. Amendment 5 applies to all federal laws, the federal statutes, the United States Code. Yes, yes, yes. And the United States Constitution. Yeah. Treaty obligations, any of those treaties that were written after the Constitution had been ratified. You remember those signatures. And then Amendment number 14 applies to each and every state of the United States that thinks that they have to enforce a court order because a court issued it using a forgery of an elected oath of office. Pooch! Now, I know on the face of it, when it says that he did not receive actual notice, he was or was not there, and it was not issued according to the requirements of the VAWA, you decided to continue to enforce it from the time of November 20th of 2015 when I informed you that my right to due process is and was being violated. Petitioner didn't sign it. He issued it for 10 years. Now, this concept of the mental health evaluation and treatment, it doesn't say anything about the mental capacity, the mental well-being or defect or illness of the person. No person. Yes. The condition is that each and every individual that has an American citizenship has the right to notice an opportunity to be heard before a court can obligate them to anything. Back in 1776, you wouldn't have thought they had mental illness, but a lot of the original individuals that wrote the Constitution, yeah, crazy. They're just totally fucking nut jobs. Sitting around writing a stupid Constitution. Discussing, well, should we put this in there? Should we look at the wording of it? It doesn't say no mentally ill person shall be deprived of life, liberty, or property without due process of law. Yes, it doesn't say that. Now, they didn't include the mentally ill in the original drafting of the Constitution. Poop. Yeah, well, every time Brent Baisden or any other judge agreed to this mental health evaluation and treatment, if recommended, without protecting the person, yes, known as the respondent's rights to life, liberty, and property, yes, without proof of actual service, yes, dissolution of marriage, pow, pow, pow. Now, this is really interesting because it says here the government cannot deny an individual their substantive rights, the substantive due process rights. Whereas, yes, the government cannot deprive an individual of notice and an opportunity to be heard, procedural due process. Now, a lot of those in the federal government, they get confused about the procedural due process versus the substantive due process. But let's say a petitioner ran into court and said, my husband's crazy, he's in prison, and he got a tropical illness where he thinks that everybody has a chip in their body. That would be the substantive due process. The substance of the original written concerns about the mental well-being of the individual known as citizen number 1. See, what is procedural due process? Having court hearings without notice? Yes, yes, yes. Cannot deprive an individual, crazy or sane, without notice and an opportunity to be heard. Pooch. Then there's the cannot deny an individual their substantive rights because of the substantive due process. I would say that when she motioned the court for a protection order in 2011, there was a lot of untruths, false. There was some lying going on in that actual statement. Yes, there was. Now, let's say I got to suing you today for violating the substantive due process of each and every statement that has any fraud. Yes, any fraudulent statements. No! I'm going to sue you for violating the procedural due process of requiring notice before court hearings. Yes. But today we're going to work on the substantive due process of the United